Hi, my name is Michael Mireles.
And I'm Reyna, and today we will be presenting our Fisher versus University of Texas at Austin case on the side of University of Texas at Austin.
When Caucasian Abigail Fisher applied to the University of Texas at Austin in 2008 and was denied acceptance, she contended that her race infringed on her being viewed as equal amidst other applicants coming from a minority group. Fisher then took this civil rights case to a court of law, testifying on the behalf of herself and millions of others who perceive affirmative action as an unconstitutional act. Fisher then insinuated the question that has come up time and time again: whether or not the Equal Protection Clause of the 14th Amendment permits the consideration of race in the university application process. The answer is that there is indeed a need to use race as a decisive factor in the university application process in order to assure that individuals coming from once ostracized groups are given the opportunity to meet their fullest potential. When Fisher was rejected from the 16th listed top public university in the nation with an acceptance rate of 39.7%, a university that not only her father attended, but also that her sister was attending at the time as well, she fell under the assumption that her race had been such a decisive factor in the application process that it may have been very well why she was denied. However, it is evident that this is not the case. See Fisher's grade point average of a 3.59 on her 4.0 scale, according to the Huffington Post, already deemed her insufficient when merely looking at the standard GPA for UT, a 3.71. Already at a disadvantage, the plaintiff's SAT score was an 1180, measured on the former 1600-point scale, which was relatively good but nowhere near the standards of the highly selected flagship university.
But what really shows the inadequacy of the plaintiff's argument is the 42 of 47 Caucasian students who were admitted despite having lower academic index, personal achievement index scores than she did. On the other end, UT Austin rejected 168 Latino and African American students with equal or better scores than Fisher. And it goes beyond this. UT News has provided statistics showing that of the 50,006 students enrolled at UT in 2008, Caucasians constituted for 27,234, over half of the population. As of now, Caucasians account for 45.1% of UT's population, meaning that although the population of whites has dropped in the university, it is no drastic number in which any individual should concern themselves with. Whites continue to be the majority race, only followed by the 19.5% of the population comprised by Hispanics. Moreover, these numbers carry on to depict that affirmative action, though its origin dates back to 1961, has not yet accomplished its goal of graduating more minorities.
But is race-conscious affirmative action consistent with the 14th Amendment? Justices of the Supreme Court have outlined and maintained a system that ensures that affirmative action does not violate the 14th Amendment. It began with the 1978 case of Bach versus Regents of the University of California, which set the standards that all universities were meant to follow in order to avoid any claims of having violated the Equal Protection Clause of the 14th Amendment. In an 8-1 decision for Bach, justices of this court contended that any racial quota system supported by government violated the Civil Rights Act of 1964, meaning that the special program run by Davis Medical School and the 16 places in a class of 100 specifically reserved for applicants coming from this special admissions program made the school's use of race unconstitutional. What the court does allow, however, is a system resembling to the final decision in the 2003 Supreme Court case Grutter versus Bollinger, which upheld that the Equal Protection Clause does not prohibit the law school's narrowly tailored use of race in admissions decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. This is similar to the holistic approach that takes for each of its students. This arbitrary system can often, as it has for the past few years, generate a series of complications. But what remains essential in acknowledging is that they do not reserve a number of spots or claim some percentage to be constituted for only by minority groups. Instead, UT has a narrowly tailored goal, similar to that of the University of Michigan Law School, in striving for a more diverse student body, while complying with the additional grounds established by Grutter versus Bollinger. The University of Texas at Austin holds a compelling state interest in creating educational benefits, and because there is an application of strict scrutiny, the use of race in the admissions process as a means to increase the critical mass of minority student bodies is, by law, acceptable, and just. Any other claim would be considerably erroneous because the set quota system that justices have claimed violates the 14th Amendment remains absent at UT at Austin, while they austerely ensure that a narrowly tailored goal remains altogether present. And though we can easily come to the conjecture that the consideration of race is not so decisive a factor in the application process, and thus can be done away with, the repercussions that would be brought through this would alter our outtake in a matter of seconds.
Now on to why race is such a crucial aspect of the admissions process despite being such a small factor. Why not remove it and do away with the predicament it has put universities in today? Well, through Proposition 209, also known as the California Civil Rights Initiative, the first legislation to contest affirmative action policies was enacted. Since its passing on November 5, 1996, many supporters of the bill have contested that graduation rates for minorities in California's higher learning institutes have increased because of said legislation. However, growth in graduation rates, while an indicator of relative university success, do not appease for the bill's limit on the enrollment opportunity of minorities. In fact, while graduation rates have increased among all racial masses in California schools, minority enrollment has dropped significantly. Within the first 3 years of the passing of Proposition 209, the number of admitted African Americans, Latino, and American Indian undergraduates decreased by 58%. More recently, this issue allowed Gibber Basri, outgoing Vice Chancellor for Equity and Inclusion of UC Berkeley, to aid in the creation of the African American Initiative. As of today, African American enrollment in UC Berkeley accounts only for 3% of the student population. Minority enrollment in California colleges has shown no increase since 1998, which is discouraging since Hispanic population in California has surpassed the commonplace majority of white residents throughout the nation. Unsurprisingly, little effort to institute ethnic integration in university bodies has resulted in a widening composite of Hispanics who are receiving fewer educational opportunities because of the disappearance of systems such as an admissions process that considers race. According to the Campaign for College Opportunity, fewer than 2 in 10 working-age Latino adults have a college degree. This reality is accounted by the worsening oppositions Hispanics and other minorities are progressively facing. With growing fees, lower minority enrollment, and a widening educational gap correlated to the socioeconomic status, California is unintentionally cultivating a state where Hispanics constitute the majority of the population, yet are one of the most underrepresented in terms of higher education, a crisis no state, certainly not Texas, could afford. But the adversity minority groups face is not solely limited to obtaining an education. Rather, their ethnicity detains them, making them aspire that their color, religion, or culture were more reminiscent to the white nativists of America. In a recent study conducted in Milwaukee, Wisconsin, Deva Padger conducted a matched pair experiment in which she had male testers apply for the same entry-level jobs advertised in local newspapers. She gave these assistants fake credentials, making them equivalent in terms of education, job experience, and so on. Half were white and half were black. Though the study was meant to test the effect of having a criminal background, the effects of being black proved to be far more determinant of whether or not the applicant received an interview callback. From those applicants who held a criminal record, 17% white males were given a callback. Of black applicants possessing a criminal record, only 5% were called back. And from those applicants without a criminal record, 34% of whites were given a callback. Meanwhile, only 14% of blacks were called back. Compare the percentage of whites who held a criminal background and were called back to the percentage of African Americans with an absence of any sort of criminal background who were called back. A 3% divergence in favor of whites with a criminal background. It appears that though we try to avert from the inherent inclination to hire or accept whites over blacks, we wither in this matter. But affirmative action provides for a tangent.
With that being said, and through the terms to which the University of Texas at Austin coincides by, we hope that you maintain the use of affirmative action. Not only is it advantageous to the prosperity of an individual, to a university, to a community, but also to the nation as a whole. It ensures us that justice will be served even for those individuals coming from a once ostracized, slaved ancestry. Thank you.
How should this court evaluate race-conscious university admissions programs? Please cite specific Supreme Court cases.
Race-conscious university admissions programs have been scrutinized since 1978 and continue to be of controversy to this day. Proceeding from previous case outcomes, race consciousness holds unestimated value as universities provide a helping hand towards minorities. That being said, we ask the court to evaluate such programs under prior conditions established by previous court cases. Firstly, race-conscious admissions programs are justly applicable in the university setting. University of California versus Bach in 1978 determined that the use of race as a criterion in admissions decisions in higher education was constitutionally permissible. This refers to the University of California's implementation of race as one of the many factors used in their admissions programs. It should be noted that race may only be used if there is a state compelling interest. In Parents Involved in Community Schools versus the Seattle School District No. 1, the Supreme Court ruled that the desirable outcome of the use of race in admissions programs had to pass strict scrutiny. Specifically, the Seattle School District did not meet these requirements because their use of race lacked the narrow tailoring that is necessary for a race-conscious program. Moreover, it was concurred that their use of race was aligned with their demographic goals and not any outcomes that could be deemed as crucial for the betterment of higher education. These circumstances proved insufficient to meet the standards set by Grutter versus Bollinger in 2003, which affirmed that the Equal Protection Clause does not prohibit narrowly tailored use of race in admissions decisions to further state compelling interest. Secondly, race-conscious university programs must be distinguished from other civil programs for their valid applicability and fulfillment of predetermined qualifications. Ritchie versus DeStefano, 2009, brought about the question as to whether federal courts can allow municipalities to bypass local laws that require strict compliance with race-blind merit selection procedures. The answer is no, and we couldn't agree more. While attempting to combat minority disparity in the broad workforce, the city of New Haven did in fact violate Title VII of the Civil Rights Act of 1964, which prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. What distinguishes this case from race-conscious university admissions programs is the fact that the New Haven Civil Service Board, failing to certify 2 exams because of their presumed provocation of race imbalance, did not pass strict scrutiny because such a racial imbalance would not hinder any business or deny any business necessity as deemed by the state.
Has the University of Texas at Austin shown that its use of race as an admissions plus factor meets the strict scrutiny test? Please explain the strict scrutiny test and how it applies in this case.
The University of Texas at Austin has demonstrated the qualifications needed to pass strict scrutiny. Strict scrutiny is a form of judicial review in which laws are passed and they must satisfy a compelling governmental interest under a narrowly tailored plan that will not only ensure the goals of the law are met, but also that the regulations of the law are specifically meant to and will fulfill the governmental interest. In this case, the University of Texas at Austin includes race as part of the Personal Achievement Index in their holistic approach. This is because the University of Texas at Austin wants to promote a diverse student body that will be exposed to a variety of perspectives and backgrounds that will prepare students for the future ahead. This governmental interest as well as state compelling interests are the reason why the University of Texas at Austin wishes to support the growth of minority students on campus. In University of California Regents versus Bach, justices of this court contended that any racial quota system supported by government violated the Civil Rights Act of 1964. However, the University of Texas at Austin does not have a quantitative goal for the number of minorities it wishes to admit. Rather, a critical mass is implemented instead, which allows for deviation from the estimated goal and does not aggressively favor minority students in place of others.
Does the language of the 14th Amendment support the notion of race-based affirmative action? Why or why not?
The Equal Protection Clause of the 14th Amendment is the most prevalent in this particular case. That being said, its language, as originally written in the Constitution, supports race-based affirmative action. No state within the U.S. may abridge, curtail the privileges or immunities. These undoubtedly refer to the exercise of rights granted to all U.S. citizens. Nor shall any state deny any person of life, liberty, or property, nor deny to any person within its jurisdiction the equal protection of the laws. This final decree is what allows the U.S. to create and shape laws in a way that prevents the subordination of some groups by others. Laws are constructed to instill not just equality, but also equity. All citizens reserve the right to have fair opportunity to life, liberty, or property. In this sense, for example, income taxes serve to maintain fairness because higher income residents pay more than lower income residents. This is not because the government is applying a law unequally to its citizens. This is because higher income residents can afford to pay more taxes than lower income residents, making such taxes fair for all constituents. Affirmative action works in a similar manner, promoting equity among minority groups who face greater obstacles in the academic setting because of financial and social circumstance. Equal protection of the laws means that laws should be able to grant equal support for all its citizens, which in this case means minority groups will receive some assistance through race-conscious programs.
Looking at legislation passed during the Reconstruction era, including the Freedmen's Bureau, does the weight of historical evidence support affirmative action extending to modern-day programs? Why or why not? What arguments were raised by proponents and opponents of the Freedmen's Bureau? In answering this question, please cite specific legislation.
Amidst the third year of the Civil War, President Abraham Lincoln issued the Emancipation Proclamation, freeing a mere 500,000 slaves. However, the life of African Americans were, as James Johnson, a 75-year-old ex-slave, described in his narrative, worse than before. And why? Well, President Lincoln freed orphans with no place to go, men and women with no food to eat, or even a place to lie for that matter. The Act of March 3, 1865, Chapter 90, Section 1, more commonly referred to as the Freedmen's Bureau, provided something of a tangent, relief of freedmen and refugees. Through this act, Congress provided slaves with clothing, food, water, health care, communication with family members, and jobs. But this act went a step further in that it provided institutions for African Americans to obtain an education, something they had long been deprived of. In 1866, the life of this act was extended, while its powers regarding education were expanded. Sadly, this act ceased to exist by January of 1869, following the implication of the Act of July 25, 1868, Chapter 245, Section 2. And though the Educational Department of the Bureau was intended to continue indefinitely as a separate entity, it failed to do so following the resignation of the General Superintendent of Education, Reverend Alford. Representative Charles Sumner, this man held an ideology my partner and I deemed to be vital to education, innovation, and to the prosperity of this nation. At the Congressional Globe 38th Congress, First Session, 2799, 1865, Representative Sumner argued on the behalf of freedmen, asserting that they were not idle beings. They were instead in need of not support, but rather assistance in acquiring work and assurance that they would not be left to perish. This is what affirmative action does for members of minority groups. It takes individuals of the said group and allows them to thrive in their education, to break free from the chains that were set on preceding generations. And to acclaim this to be unconstitutional is unjust in itself. No, America does not leave communities to perish. She seeks to be the superpower of the world, and in order to do so, we must ensure that all communities flourish, that citizens coming from minority groups are given the opportunity to acquire a post-secondary education, to innovate, to implement what they have learned to their lacking community, which is why affirmative action must persist in its existence, why it cannot be left to die, as the Educational Department of the Bureau was. Opponents of the Freedmen's Bureau provide for several plausible arguments. The most common one, reminiscent to what was said by Representative James G. Blaine in the Congressional Globe, 44th Congress, First Session, 229, 1875, that there is no longer any distinction between American citizens, that we are all equal before the law. And though this nation has come to esteem itself on the education it grants every child, we continue to fail in recognizing the severe disparity that remains present in accessing quality schools that will in turn lead to a higher education avenue. The Freedmen's Bureau is resemblant to affirmative action in this way. It attempts to aid those who lack the resources necessary to set a path in which they are more capable of supporting themselves. Proponents such as General Oliver Howard attest to this, claiming that the Freedmen's Bureau was nothing more than a charitable institution meant to fit them for independent self-support. Affirmative action attempts to do this for countless minorities who possess the potential to thrive in attaining a superb education, but reside in a community where there are inadequate resources.
What are the lingering effects of slavery in modern society? Is it the state's responsibility to ensure that all grudges and incidents of slavery are fully addressed?
Even after a century and a half, this nation continues to feel the impact of the great American original sin, racism. It is rather unfathomable to think of those attempting to reduce the works of affirmative action, which are only hitting the surface as they proceed in integrating and giving opportunities to those who have long been marginalized. It took this nation nearly a century and a half after declaring independence to abolish slavery. It then took another century for discrimination to somewhat diminish. And yet we expect the lingering effects of slavery and discrimination to merely vanish into thin air. To believe this to be even remotely possible is impractical. Racial inequality continues to exist amidst universities across the nation. We have seen this in cases as recent as the University of Oklahoma. Moreover, the African American unemployment rate, 10.4%, continues to skyrocket, as have Hispanic unemployment rates, 6.6%. These two are the highest in comparison to any other race in the U.S. As civil rights activist Reverend Al Sharpton stated in his Huffington Post article, the right wing and others often try to pretend that we are somehow in some sort of post-racial society when the reality is we still have our work cut out for us. Indeed is this so. But America has now been given the opportunity to depict its sympathy towards those who were once ostracized. And it is to the utmost necessity that we do exactly that.
What do you make of the argument that we should live in a colorblind society?
A colorblind society is well warranted in light of social stigma and racial prejudice. However, current realities make such a goal impossible to materialize. Because such social and economic disparities exist, to establish a colorblind society would be to ignore the malicious circumstances cultured by America in the past centuries. We are at a crossroads between attempting to make race little predetermination for the future, while also attempting to correct the current injustices that manifest in low minority enrollment and increasingly obstructive financial barriers that deter minorities from reaching higher education. The University of Texas at Austin is combating this issue in the best way possible. And in accordance with decisions from the Supreme Court, this university is paving the way for a true colorblind society by challenging low minority enrollment with race-conscious admissions programs.